All right, our second case on the docket this morning is Kevin Patrick Kelley Jr. versus the state of Florida. It's case number 21-1569. Counsel for the appellant, Mr. Gosney.
Good morning, Your Honors. Steve Gosney for Mr. Kelley, and we have I'd like to have 10 and 10 if we could.
Oh, I probably should have asked you that, yeah.
It's no problem. I know my opponent over here, so I need maximum rebuttal. This case is it's really rather simple. It's whether the state can paint a language cloud of words to make somebody look really bad in front of a jury of parents, and then the parents will sit in judgment and say, that's really a bad parent. That subjective parenting standard versus the facts of this case, which is you have an obviously drunk Mr. Kelley walking down the middle of the street with his 4-year-old stepson on a little push scooter, and he's in the middle of the road, and a off-duty cop, it's a 25-mile-per-hour side street next to a playground, and a off-duty cop comes up, honks his horn, he doesn't hear it the first time, honks the second time, and gets off. And for that, my client gets convicted of felony child neglect and gets sentenced to 10 years in prison and a $182,000 fine. So the question is, and you know, the law should be objective. And this subjectively, we can paint pictures, we can paint word clouds that make him look bad. The little child he had dirt on his face and he didn't have a shirt on, and he was scooting there. You can paint all those pictures, but the objective question is whether or not a drunk parent in a 25-mile-per-hour road, walking his child to the thing, is that felony child neglect?
With sidewalks on either side of the road.
That's correct. That's correct. There's no doubt that my client was drunk, and there's no doubt he was in the middle of the road with his 4-year-old on his little scooter. So those are the facts. Is that sufficient?
At 4:30 in the afternoon.
Right. And it was a bright, sunny day. There was no question about visibility. It was not. And the first thing I think that needs to be considered is, it's like, well, that's bad parenting. But bad parenting is not culpable negligence. And it's simple. It's not. This really isn't even simple negligence, and I pointed that out when I thought about it. Because the child wasn't harmed. The only time the child was ever...
You have to have harm. Is harm an element of the crime?
Harm is not an element, but I wanted to point out the fact that in a general negligence civil tort, there would be no injury here. The only injury is when the child...
We're not in a civil court. We're in a criminal court.
Fair enough. But in culpable negligence, what is required? The requirement is that there is some fear by which this child would have great bodily harm, right, or death. And the fear is that he's going to get run over by a car. Fair enough. But that fear does not...
I think the fear is that the age of the child is then submitting him or herself to the care of the adult. And the adult in this case recognizes, or maybe doesn't recognize, the fact that there are sidewalks on either side of the street and chooses to march the child down the middle of the road, double yellow lines at 4:30 in the afternoon. And then when approached by a vehicle from behind and the horn is honked, there's no reaction from the adult. Was there a reaction from the child?
That's not in the record.
Okay. So we don't even know if the child at that age was capable of understanding the danger to then get out of the road. Is that correct?
Well, that's true, but that would be a state burden to put on that evidence if there was some standard there. I mean, I think that he is the caregiver. It's a 4-year-old child. We can make assumptions from that. I don't think that's problematic. Whether or not...
Should we make assumptions about the age of the child and the child's capability, or should there be evidence in the record about the capability of the child when we're trying to evaluate whether or not there was culpable negligence? For example, Judge Wallace asked a wonderful question. Did the child react when there was a honk? Do we know if the child understands traffic? Do we know if the child knows that they should be on the sidewalk, or if they see a vehicle, what they should do? Was there any evidence that the state should have put on in their case in chief about the child's capability, or should the jury just make assumptions based upon their experience with children of similar age?
Well, there is no evidence, and it is a state's burden, but I'd also make a note that Florida statutes 827.03(1)(e provides that drivers have an obligation to look out for people with, oops, I'm sorry, wrong statute. The driver, there's a statute, and it's cited in the briefs, that requires drivers to be aware of people with certain physical or mental disabilities or children. So the driver, and this is a 25-mile-per-hour side street next to a playground. This is not I-75. It's not a high, and that, if you remember, there was some clouding about, well, this road is sometimes trafficked hard, but at this time it was not, and that was one of the points I brought up. It was a minor point, but it's the fact that they're trying to paint the worst possible scenario, an image, and plant that image in the parents, jurors' minds as to all these terrible possibilities.
Right, but when we're looking at the sufficiency of the evidence and whether or not it goes to the jury, there are some cases, for instance, the case that both parties argued dealing with the child that was descending from the stairs.
Right,
Correct?
very good. In fact, I think that's the controlling case if I was going to pick one.
And in that case, there was much discussion about the child's capability. The child had climbed and descended these stairs. The child had only fallen once to their knowledge. The child fell on the last stairwell. My question in that case is, there was evidence put on the child's capability when we judged whether or not the adult supervising the child was culpably negligent, what they should have known about that child's capability. My question is, was there similar requirement in this case to get to a jury that the state should have put on evidence of the child's capability?
I'm not sure if that's determinative, whether they should have. If they were required to, they failed to do so. So, I mean, I know that's a little bit of a dodge, but I think that the issue in this case is whether or not the simple action, the singular action of walking down a 25-mile-per-hour road, let's just leave it at that, drunk or not, was that felony culpable criminal child negligence?
I got to ask you about, and you've used this characterization, and it's not false, but you've used this characterization a couple of times as it relates to drunk. I mean, legally drunk is .08.
Sure.
This is, well, let me phrase
Falling
it
down
differently.
drunk. I understand. He's drunk.
How do we view that? Because it seems like it's a bit of a spectrum. Because if it's .08, I think you might potentially be criminalizing every suburban birthday party. If it is, however, 24 beers somehow disappear in the span of 3 hours, the guy literally can't stand up. He's trying to fight strangers, and he's got no shoes on. And we look at that phrase, supervision. How does that level of drunkenness, statutorily bear on that phrase, supervision? Can we at least assume that a jury might be able to take that into account as to his ability to supervise .08 versus 24 beers in 3 hours?
The Medina case talks about that in that this person is completely not paying attention. So in Medina, that person is not paying attention at all. And I would go back to the Florida statutes 13015, which requires drivers to pay attention to falling down drunk people in these residential areas or for children. So drivers, is it culpably negligent criminal for him to drunkenly rely on driver's good judgment?
Would you at least acknowledge, though, that it's baked into the statute in the sense that the level of ability to supervise based on drunkenness or indifference is a factor that could theoretically be weighed?
I'm not certain about that, because are we criminalizing parenting while drunk? That's not the statute. I mean, it's not a felony to be falling down drunk with a child in the house, and there's case law to support that.
So would it be then your contention that that's not something that a trier of fact should consider at all?
Well, there's a totality. I would say that there is a totality of the circumstances consideration. So, the question, and that's why I want to eliminate these things about he's shirtless and he's got dirt on his face or whatever, he doesn't have shoes on, because those are just facts to paint my client as a bad parent, right? But bad parenting is not the felony. Same thing with falling down drunk and being a parent is not a felony.
I want to try to separate your issue 2 from your issue 1, because I understand that you're making systemic arguments about the validity of the statute. So let's set that aside to the extent, and I'm not asking you to concede your second issue, but let's set it aside for a second to the extent that we can, and just ask about the statute as it's written, and talk about that word supervise. How can the faculties of the supervisor not be a factor?
Well, it is a factor in that it's part of the totality of the circumstances. The question, though, when it comes to a singular instance of alleged child neglect, is whether the fear of great bodily harm, death or great bodily harm, it's kind of that's paraphrasing, but the statute is, what is the feared great bodily harm? And that's why the no shirt on is a red herring, because
well, you're talking about two separate things.
Right, but it's similar.
And I'm definitely going to talk to your colleague about the no shirt on for the child, because as it relates to the reasonable death or great bodily harm of the child going shirtless at 59 degrees, I don't know if I'm there either. But I'm not talking about the child. I'm talking about your client. And I'm talking about his physical state.
It is part. I think it's part. It is a reasonable thing for the trial court to admit, because it's part of the totality of the circumstances and his ability to supervise. But what I'm saying is these facts, as given in the totality of the circumstances, are not sufficient to find culpable negligence under the case law. So, I don't. The following the level of drunkenness. Sure, that's a factor, but is that sufficient? I don't think it's sufficient to reach the level of culpable negligence, which is very high, and we are basically, this case is criminalizing drunken parenting or bad parenting, and that's one of the reasons the statute's had such problems. And I'm arguing point 2 as an alternative, because if this case is, if it is a felony, then we are criminalizing parenting, and that is subject to, that's overbroad and vague. I'm going to hold on to some of my time here. Thank you.
Morning, counsel.
May it please the court, my name is Chris Davenport, and I represent the state of Florida. First of all, as to the clothing issue, that wasn't to show that the child was in danger, it was to show the lack of supervision. So it went to, his culpable negligence. He was so drunk, he took this kid out without any clothes on, basically, with just wearing a pair of shorts. And that's, again, totality of the circumstances. Was that definitive? Of course not, but it's another factor. It's one of the things that alerted the 911 caller. It's one of the things that concerned the guy at the playground. They saw this kid with just shorts on. It immediately put their hackles up. Gee, he's not being supervised. So did that make it, dangerous of great physical injury? No, but it goes to his judgment and it goes to his lack of supervision. So that's what the clothing was about.
If there is no evidence of intoxication, have you met your burden?
I think that would be a harder case, because I think a reasonable adult who has a kid on a scooter in the middle of the road would be able to protect the kid. If we had all the same facts and the truck came up behind him and neither one of them responded, and the truck honked his horn and he kept walking, and the truck had to tell him a second time to get off the road, and there's cars coming in both directions at that point, perhaps. But I think the fact that he was staggering drunk showed that he couldn't supervise the child at all, versus, if it was a capable person walking the child down the road. I think that'd be a closer case.
Excuse me, what do we make of the fact that he was actually supervising the child? In other words, I think your case probably gets stronger if that child is pedaling his Thomas the Tank Engine down the road by himself.
Yes.
And for example, the defendant is passed out on the side of the road. So what do we make of the fact that if we look at the statutory language and it talks about supervision, that the defendant was actually supervising the child?
Well, he was actually present. I would submit he was not actually supervising the child. He was with the child, but he wasn't supervising the child, because someone who was supervising the child in the middle of the road when a truck came up behind him would have moved the child to the sidewalk. Someone who was supervising a child would have moved when the truck honked the first time.
Is his very presence next to the child making the child safer, though, in terms of increasing the visual profile on the road and making it less likely, for example, that the child would be hit first, if you're talking about where a bumper is on a truck?
Probably, yeah. I mean, it does certainly made him more visible, yes.
Does the record indicate that the defendant is behind the child?
It doesn't really say exactly where they were. They just said next to him, but
Does
they
the
didn't.
record indicate any time lapse between the first and the second honk?
It was long enough for the officer to become more concerned that he didn't respond right away. But I don't think he said like a time frame.
Is it culpable negligence if the child's 7?
I think that's a closer case, but yes, I would say a 7-year-old who's in the middle of the street with a drunk caretaker, I think that would be closer. It probably depends on the maturity of the 7-year-old in that case.
Is that an evidence issue for the state, that the state should have put on evidence of the child's maturity or capability at the age of 4?
I think the state put on his age, and the mother testified that, of course, they didn't let him play in the middle of the road, that was not their habit. I think they didn't need an expert to say that a 4-year-old lacks the judgment to get out of the street. I mean, we don't let 4-year-olds cross the street by themselves unless they're remarkably mature, and there's no evidence this kid was. So I would say, it's something that the defense could argue. They didn't argue that here. I think maybe the defense could have asked mom, gee, does this kid go out by himself, and is he capable of crossing roads and things like that? The defense didn't ask that. As far as the state having a burden to show that, I think by showing that that's not something they did with this child, and the child was 4, and his lack of reaction when the truck came up behind him. I mean, the officer didn't talk about whether or not the child reacted to the honk, but he said, I'm behind him in this big, loud truck, and neither one of them reacted. That shows me a kid who's not particularly savvy.
What evidence was there that it was a loud truck?
Huh?
What evidence was it that it was a loud truck?
The
I understand
officer-
that there was a honk, but I mean every
Right,
car
before
every
that.
every car can honk.
Every car can honk. The deputy testified that he was surprised the defendant didn't react when he pulled up behind him because he has a loud exhaust on his truck. And if you're outside today, I think you recognize that loud exhausts can be quite a warning that you should get out of the way.
Do we look at, for purposes of our decision on issue 1, do we look at what could have been the conditions on that road, or what were the conditions on that road?
I think the could have been conditions, again, go to his judgment and his failure to supervise. Because if I have a 4-year-old and I want to take him to walk down the middle of the road for some reason, if I take him to Orange Avenue, even if there's no cars there when I first take him out there, that's a lot different from taking him to this side street on the other side of the court where there's never any cars. So I think that's, again, part of the totality of the circumstances.
So we look at the testimony that typically a car comes down that road every 2 to 3 minutes on one hand. And then we look at what actually happened in this case, which it sounds like the off-duty officer was the only car on that road during the time. He had no trouble seeing the defendant and the child. In fact, it seems like the testimony was that as soon as he turned onto that road, he saw him. There was never any issue of, in that sense, danger to the child of being run over on that day because of those particular facts. On the other hand, the whole statute, and I think Judge Wallace got to this a little bit, the whole statute isn't couched as what did happen. It's couched as what could have happened.
Right.
I confess to you that I'm having a lot of trouble reconciling those two ideas in terms of resolving issue 1, and wondered if you might give a little bit of direction or help.
I think if he was in the middle of I-4 and there was no traffic at that time and somebody was parked in the median and saw the child and the dad walking down I-4, I think that would still be culpably negligent. Because even though there was no traffic at the time, he's exposing him to a reasonable possibility. All it would take is one car, and the kid is going to be in a lot of trouble. But
what about your example of a neighborhood, though, where it's lightly trafficked? Or let's just put it out in western Kansas where you can see to the horizon and there's a big dust cloud that comes up every time that somebody's coming at you. What if that one car is going 100 miles an hour?
I think that would be harder to prove our case. But let me add here that the off-duty deputy wasn't the only car. He was the first car but he wasn't the only car. He saw him right away, and he even testified, I wasn't that concerned. I think he assumed that they were crossing the road, so they were jaywalking. Is jaywalking culpably negligence? I think that's a harder sell. But by the time he honked the horn the second time, there were 3 or 4 cars behind him and cars coming from the other direction. So we don't have a situation where there's no traffic on the road at the time. Both of those things are the same here. It's reasonably dangerous, objectively and subjectively. There were a bunch of cars there. The off-duty deputy with his big truck with the loud exhaust was holding those cars back. And I think,
If I'm wrong, but I think what the record was is that certainly the child was in no danger of the cars behind. Or certainly there's no record evidence that the child was in danger of the cars behind. I think the off-duty officer's testimony was that they were piling up behind him.
they were piling up behind him. He was protecting the child. The off-duty deputy was supervising that child better than the defendant was because he was protecting him by putting his truck in front of him.
And I think that his testimony further was that by the time he honked the horn a second time, that there might have been a car coming in the opposite direction, but I don't think we have anything other than that.
Right, but there were 3 or 4 cars behind him that he was holding back. He was blocking the road with his truck, essentially. And then there were cars coming from the other direction. That's when he got concerned, why he honked the car horn the second time, to try and get the guy out of the road before things got really, really dangerous.
Let me ask you about the instrumentality in terms of the car. I mean, I think what the state's argument has to be is that the child was in reasonable danger of death or great bodily harm of being hit by a car.
Yes.
Or it's not getting hypothermia or
Right.
falling down at the playground. All right,
Right.
so if we're talking about the car, I was looking at the Arnold case. You know, it was the trailer with the knife exposed on the table. And in
Right.
that particular case, the Arnold court said that just the possibility of the child being cut by the knife isn't going to get you there. So in what sense do we talk about just the fact that it's cars? How do we weigh that?
Well, first of all, I would say in the Wynn case, the kid was left on the side of the road, 4-year-old, busier street, no supervision versus a drunk supervisor, which I would submit would be about the same level of supervision. And they said that's reasonably dangerous. He could get hit by a car. If I had a knife if he was in the middle of a knife throwing contest, I think the argument in Arnold would have been a lot different. And I think if we would have been in a parking lot with a bunch of parked cars that could start up at any time, that would be more analogous to Arnold than what we have here. And I would say this one's closer to Wynn.
What
Because
about
you're in a street.
What about a unsecured loaded gun?
An unsecured what? I'm sorry?
Unsecured loaded gun. So I'm trying to put you between an operative car and a knife. Maybe I'm trying to put you outside of an operative car. But just a situation in which any parent in the state of Florida has a loaded gun in, say, a nightstand. And the worst thing that you can possibly imagine with a kid happens and they get a hold of the gun and they shoot and kill themselves or shoot and gravely bodily injure themselves. Crime under the statute always?
I would say that would be up to the jury, and the jury's verdict of guilt would be supported by the record unless kind of depends on where the gun would be. If it's in a low drawer next to the kids' playthings, I think that would be different from on a high shelf with a 12-year-old versus in a drawer with a 2-year-old.
Did you say, though, that it's always a jury issue?
I would say it would most likely be a jury issue, yeah. I mean, look, if they had it unlocked in a shelf over the stove and a 12-year-old got a ladder and went up there, I think that would be a tough argument for us to make.
Ms. Davenport, I assume that you proceeded in the trial court as far as the child neglect with, it talks about care, supervision, services to maintain the child's physical health. It appears to me, I don't think it's a stretch to say you were proceeding under the supervision aspect of that. Is that correct?
Yes.
Okay, so where in this fact scenario, I mean, all the facts that we have here, what was the moment that the state met the threshold burden to prove that there was a lack of supervision?
I would say when the off-duty officer turned on that street, there was a car there, it was him, he was careful, thank God. I would say right then, when he's in the middle of the street with a car on it, and he doesn't take any action to get out of the road.
So you're saying that that threshold occurred immediately prior to the off-duty officer honking his horn?
I would say yes, that was enough right there. But we have more than that, so if that wasn't enough, we do have more.
Okay, and I guess my concern is where does the relevance of the alcohol come in order for the state to prove the threshold?
Well, they saw him stumbling on the road before they got behind him. The 911 caller said the guy fell down and it took him a while to get up. And then this car got behind him and honked. So this was all in the same time frame. He was stumbling around out there at the time. I think, again, the intoxication adds to it, makes it a stronger case for us. The fact that traffic was backing up makes it a stronger case for us. The fact that the cars were coming from the other direction makes it a stronger case for us. But as far as, if we had stopped all the testimony, I think we had enough as soon as he was in the road with the traffic and didn't get out of there when the loud truck got behind him, didn't react to the loud
I have
truck.
to challenge that in a sense, though, and I think that's a really good question, because if the intoxication doesn't factor into it at all, what if he was having a medical crisis?
I think that then you wouldn't have been acting in a culpable, negligent manner. You have to
Right.
have some kind of
Right, so you have to
gross-
you have
well,
to have the
that's true. Yeah,
drunkenness,
if he was
right?
just, or if he had a seizure and fell, that would have been
Yeah,
different. Yeah,
I think you have to have the drunkenness.
You're right with that. That's
And-
true.
And it also seems, going back to my questions to your colleague, that you've got to have an appropriate level of drunkenness. Because if you're .08, again, in my somewhat facetious children's birthday party example, you have to have a certain level of intoxication in conjunction with going down the road.
Absolutely. If he had just had the smell of alcohol in his breath, but he was supervising that kid and just made a dumb decision, that's a lot different from stumbling, drunk, I can't talk coherently, which is what we had here.
So going back then
So,
to Judge
yeah.
Wallace's question, when is the moment that the state met its prima facie burden to show a lack of supervision?
That's a hard question because, I'm always thinking
the
about the next
question,
case. Well, no, I don't think so.
On issue one
because-
it is, right? Because if you didn't
No.
meet your prima facie burden, then it's a reversal.
Well, we certainly met it by the time we have the second honk, traffic backing up, and the guy can't get the kid off the road without falling down. I think we met it right there for sure. What's the earliest time, I think, is a trickier question. We certainly met it here because there's all of this stuff afterwards.
So you're
that
kind of
added
making
to
your
the
last
totality of the
stand. You're
circumstances.
kind of making your last stand at the second honk.
I'm saying it's a totality of the circumstances question. And if you want to cut out some of the circumstances, how much do you cut out and we still win is a harder question. We certainly win with the totality of what we have here, where he's stumbling down drunk, doesn't react to traffic behind him, traffic's piling up. And let me just reiterate that this deputy called this a main thoroughfare. This is not a side street. It's a Saturday afternoon, so it's not as busy as rush hour, but this is a main street that there were cars on. It has a low speed limit, but we all know that that's not definitive as far as how fast cars are going. This is a main thoroughfare that he chose to put the child on. And, in the next case down the line, we have a guy who actually is supervising the child and just makes the dumb decision to walk for 200 yards on a main thoroughfare. I think it's closer without the intoxication, but I think we would still win that. But, again, totality of the circumstances. So it would depend on the age of the kid, it would depend on the traffic at the time, it would depend on a lot of factors. All of those factors weigh in our favor here. I mean, there's a 4-year-old and a really, really drunk parent.
I want to take you back to the supervision question, the Salmons case, the woman in the bar.
Uh-huh.
The reversal in that case was predicated on the fact that even though she was drinking at the time, even though she'd had the one beer and was working on the second, that this wasn't criminal behavior because she was in fact supervising the child.
Right.
It seems like she came out and met the officer who may have been looking in, so it seems like her eyes were on the child. And again, I go back to the fact that this guy was walking next to the child. You made the response, and I think it might be a good one, that he couldn't supervise because he was so drunk. Is that something, though, that was outside the record? In other words, are you saying that we should just say, and who knows, maybe the guy had a super high tolerance and that he was able to supervise better than anybody else in this courtroom would have been after knocking back 24 beers in 3 hours? Is that something that should have been part of the state's burden to show that, hey, even though the guy was literally standing there walking next to the guy, maybe not straight, maybe not upright or whatever, but he was in fact supervising at the time?
I think that's an argument for the jury to decide whether or not he was supervising in a way that satisfied the requirements of the statute. He was not, checking on the kid and had a beer. He was stumbling down the middle of the road. I think it's different to have a kid sitting in a car with the windows open happy than a kid riding, a 4-year-old riding down the middle of the road with traffic piling up in both directions. I think those are very different things. The intoxication was certainly a part of the case and certainly a factor to show that he was acting in a culpably negligent manner by taking that kid out when he was in that state, when he couldn't supervise the kid. If he was at home and the kid was in a playpen, I don't think we could meet our burden here. He chose to take that kid out down the road, down to the park, and not walk on the sidewalk, put him in the middle of the road on this little scooter. I mean, he made a lot of willful choices there when he was in a state that he couldn't properly supervise a 4-year-old.
But similar to the case with the mother in the bar, there's a barrier between the mother and the child, and that barrier is space, and it's
Right.
going to take the mother a longer time to respond to any emergency that may arise.
Right.
Here, there's a barrier, and it is alcohol, because he's physically there, and it's going to take him 2 honks instead of 1 to respond. What do you make of that analogy?
I think that's a great analogy. I think that that's very true, that his state of inebriation did render a barrier there. I think the mother in the bar was probably negligent, but culpably negligent is a higher standard. And the jury, by the way, was told about that standard. The state didn't argue, he's just a bad parent, throw him in jail. The jury was given explicit instructions on this and what the standard is and what the state had to prove. So, I think that's a very good analogy, that it did render the supervision worse.
Any other questions?
All
Thank
right.
you.
If there are no questions, thank you.
We have a little bit more than 8 minutes left, counsel.
Awesome. The fact is about the gun example that was brought up it was that if there was a loaded gun and it was unsupervised. Well, that case, I would analogize that with the Parrish case, in which you have a father who's being held at gunpoint, the child runs out, 5-year-old child runs out, holds on and says, "Daddy, don't shoot my daddy." And the cop's there at a gunpoint, he puts his gun down, he says, "Order your kid away," because, and the parent says, "No, I'm not going to do that." Kid holds on to him, and there's that interaction. Well, and that was not culpably negligent. Now, why was that not culpably? Because he can rely on that officer to not shoot his child. Same thing that our client can rely on Section 316.013015, which says every driver shall exercise due care to avoid colliding with pedestrians and exercise proper precaution upon observing any child or obviously confused or incapacitated person. So that Parrish case goes to the gun example, and it's not culpable negligence. As far as the playground, again, we're getting a little bit of a bad parenting word cloud. Well, this road is heavily trafficked, and there's this piling up and all that. No, it was Saturday. It was 25 mile per hour. That's a playground. That's a residential playground. The reason it's 25 is because there's children there, and it's a side street. It's not the main road.
I think your colleague pointed out that there was record evidence, testimony that this was in fact a main thoroughfare. And if I look at the Wynn case, which is our other road case where the child was unsupervised wandering around the exit ramp of I-275. We don't know what that record was, but the exit ramp of I-275 certainly leaps off the page.
Right.
In terms of how you view it as I-275, well, by definition, that's an interstate, it's an exit ramp, people are coming off at highway speeds. What do we make as it relates to making this a jury question of that testimony that this is, quote, a main thoroughfare, close quote?
Right. Well, the again, this is part of the totality of the circumstances. If you read the Wynn case, the facts of that was a parent who intentionally abandoned their child in this high traffic thing.
I'm just asking you about main thoroughfare. I'm asking you
Right.
about that testimony in this case.
Well, it's a word description to make the client look bad. The fact is, it's 25 mile per hour. The fact is, it's in front of a playground. The fact is, it was a bright, sunny Saturday, 4 o'clock. It was no visibility questions.
Are those conflicts in the evidence, though? If you have, in terms of making it a closing argument, if you have one side saying, and you heard the off-duty officer say that this is a main thoroughfare, and the defense counsel stands up and says, well, he can call it an expressway all he wants, but there's a playground there. It's cars every 2 to 3 minutes. It's a 25-mile-an-hour speed limit. And you'll decide, ladies and gentlemen of the jury, how busy this road was. Do you understand my question?
Right. Well, and there's an error that they allowed that external testimony as opposed to what actually was the fact, and that was in point 6.
Well, calling it a main thoroughfare doesn't mean that I think that's separate from your fifth point on appeal. I'm just asking, calling it a main thoroughfare, does that create the jury issue?
I hope not. I hope not. I mean, when I think about 25 mile per hour main thoroughfare in front of a playground, I think of Beach Street along the river here, which I drive home every day.
Isn't it a community-based sort of decision, though? Like what might be a main thoroughfare in downtown Daytona Beach might be differently classified than a main thoroughfare in Inverness. But
it goes to the facts of this case in that, I mean, well, you were talking about Wynn. And the Wynn case is that the child gets abandoned. He goes crying. The guy slams the door, runs off, leaves the guy there. The kid goes chasing after him crying on a major highway. Now, there's a difference. When you're driving, you exercise a different duty of care on Beach Street here than you do going on to I-4. It's just you don't expect children to be in that area, whereas there's playgrounds and you have a low speed limit, and you have school zone, that gives you extra duties of care in addition to the statutory duty of care. So I think I missed the question, though. What was the
main thoroughfare? I think you got it to the best of your ability. I'm just really struggling with the idea that you have a bunch of jurors in Citrus County who might be the ultimate arbiter over what is or isn't a main thoroughfare.
Well,
and if we look at Wynn and assume effectively, correctly, that I-275 is a main thoroughfare,
right.
that, again, it leaps off the page, maybe this isn't something that you take away from the jury. Maybe it's a question of fact based on people who are in that particular community who can make that
But that goes back to when I first opened, was we're going to paint a word cloud bad picture, and this is a bad parent, and you're going to give it to 6 jurors and say, is this guy a bad parent or not? We're going to condemn him.
And I'm not fighting with you, but I'm also not word clouding. I'm using 2 words.
Well, main thoroughfare.
Yeah.
If it's a main thoroughfare, does that mean he's guilty? I mean, I think...
Does that mean it's a jury issue is my question, not that he's guilty?
This falls under Medina, Salmons Parish, Arnold. It is not Wynn, because Wynn is, we understand the difference between a high-speed thoroughfare and also the actions, the intent of the actions. A guy that just abandoned it. My guy's standing right next to him the whole time, so he doesn't hear it. We don't know is he deaf? I mean, is somebody deaf supervising the kid? Are they negligent because they're crossing the road? I mean, how much is this criminalizing just a parent who didn't hear a honking horn? And the guy gets 10 years in prison? It's crazy. And let me just go back to the abandonment. He was standing next to him the whole time. And that was uncontested. At the second honk, he moves him out. He moves him to the side. So, he doesn't hear the first honk. I mean, my Subaru doesn't have a very strong honk. Now, I know that it's like, well, it's a truck, we think air horn. This case is criminalizing a parent who is drunk, and that's not criminal. I mean, it's not a crime to be drunk and he's supervising his kid, albeit to a deficient standard, but it's not culpably negligent standard based on the case law. Let me see. I really think that statute that on the duty of drivers is important also, especially given the low speed limit in the situation. Let me see. Are there any other questions on any of the other points? I know that, no? Okay. Hey, well, thank you very much for your attention and your time, and my client begs for some relief here because the disproportionate nature of the sentence, and I think I argued this equitably, is unbelievable. And I mean, personally, I have to deal with this case. Thank you, Your Honors.
Thank you very much both for your presentation. It's a really interesting case, well argued and well briefed, and just enjoyed hearing from you both today. And we'll be in recess.